Hello everyone, hope you have an amazing day and welcome to my new blog. So today we discuss about Employee State Insurance Act 1948. So the Employee State Insurance Act incorporates a number of sections. These sections provide for medical benefits and insurance for any employees working under factories registered under the ESI Corporation. This is an exciting prospect for both an employees and a legal perspective as the beginning of a formal social security program in India. So this article will explain the highlight section of the act as well as elaborate landmark cases that prove the authenticity of the scheme and how it worked for the benefit of its employees at time of need. Now, application and scope of the Act. The Employee State Insurance Act 1948 ESI enables the financial backing and support to the working classes in times of medical distress such as sickness, maternity leaves, disorders, mental or physical maybe, disability and death. So it is a self-financed initiative which serves as a type of social security scheme to prevent the working class from any financial problem arising out of the above medical issues. Now, the constitutionally of the Act, the ESI Act serves as a constitutional instrument because of its practice of providing insurance and medical insurance, while the ESI Act is mostly executed through the ESI Corporation. The central government takes control of most of the proceedings. These controls by the central government largely contributes to the constitutionality of the Act because insurance, be it public or private, so is listed in the 7 schedules of the Indian constitutions as a union list subjects, that is, can only be legislated by central government. Now, establishments of employee state insurance corporations. The ESI Act exercises its functions through the employees state insurance corporations established via Section 3, a body created to maintain social security. It was established on 24th February 1952. The corporation is supposed to grant relief to the employees in case of medical emergencies. So the constitution of the corporation. The composition of the ESI is defined in section 4 and it is follows the Director General, Chairman appointed by the central government, Vice Chairman appointed by the central government, not more than 5 persons nominated by the central government, 1 person is present. Each state, 1 person presenting the union territories, 10% representing employees, 10 persons representing employees and 2 persons representing the medical professions, 3 members of parliament, 2 Lok Sabha and 1 Rajya Sabha, and the term of office of members of the corporations. Now, the via section 5 is following members are appointed for up to 4 years period. Director General, Chairman, Vice Chairman, the 5% nominated by the central government, the members represents each state, the members representing each union territory also. Now, eligibility for reappointment or re-election. An outgoing member of ESI, the Standing Committee of the ESIC, Employee State Insurance Corporation or the Medical Benefit Council is automatically eligible for reappointed or reappointment or re-election into office as the case may be at the pleasure of the appointing central government. Now the authentication of orders, decision, etc. The signature of the Director General of ESI is the only necessary requirement to authenticate an ongoing order to a discussion. There is no other way to authenticate on the enforced or order. Now, constitution of standing committee. The composition of the standing committee of ESI is as follows. Now, the terms, the 3 members of the within the corporation representing 3 states government, a chairman appointed by the central government, 3 members within the corporation representing employees, 3 members of within corporation representing employees. Now, terms of the office members of standing committee. The following members are appointed for 2 years period. The chairman and the 3 members representing the state. Now, Medical Benefits Council. The Director General of the ESI as chairman, the Director General of Health Service as a co-chairman, the Medical Commissioner of ESI, 1 member of each state appointed by the state government, the 3 members representing employees, 3 members of representing the employees and including 1 woman representing the medical professions. Now, the resignations of the memberships. The resignation of a member of the corporation is complete within a notice for a same or written is delivered to the central government, and his seat shall fall vacant upon acceptance of his resignations. Now, sessions of the memberships. So, a member of the ESI shall cease to be a member of his respective body, corporation, standing committee, or medical council upon failing to attend 3 consecutive meetings. So, consecutive meeting, however, the same member can be restored by the concerned body via the rules made by the central government. So, if in the option of the central government any employer, employees, or medical representatives fails to represent their qualifications, they shall cease to be the member of the ESI. Now, disqualifications. A person can be disqualified as a member of the ESI if he is declared to the unsound mind by the qualified court, if he is an undischarged insolvent, if at any time he has been convicted of an offensive regarding moral turpitude. So, filling of vacancies. Any vacancies in the office of ESI shall be filled by appointment or elections. As the case may be, the member of the ESI can only hold the ex-members of the spot in the respective committee if the original holder of that positions was found to be eligible for the same. Otherwise, the position is void. Fees and the allowances. The fees which are payable to the members of the ESI for their services can be payable at any time at the discretions of the central government. There is no definitive schedules or principal officers. The principal officers refers to the under these sections are the Director General and or Financial Commissioners. They act as the CEO of the ESI. They serve as a whole-time officers and are not permitted to undertake any work outside of the office jurisdictions without the sanctions of the central government. The time period of the appointment of any principal's offer may be not noticed exceed 5 years. Now, staff. ESI has jurisdictions to employ staff of the officers as may be necessary for the optimum running of the corporations. However, according to the prerequisites in section number 17, the sanctions for creating any staff positions has to be acquired from the central government. Their salaries shall be prescribed by the central government within a particular range which cannot be exceeded. Now, powers of the standing committee. The standing committee, with its power defined in section number 18, shall administer the affairs of the corporation and may exercise any of the powers and perform any of the functions of the corporations while authorized and under the jurisdictions of the corporations. The standing committee shall submit for the considerations and decisions of the corporations all such cases and matters as may be specified in the regulations made in this behalf. The corporation's power to promote measures for the health of the insured person. So, ESI in its jurisdictions may take initiatives that promote health and welfare among its employees while also promoting rehabilitations and re-employment for past employees who were injured or disabled in this course of employment. So, the funding and the expenditure for such initiatives is at the discretion of the central government. Now, meeting of ESI, its standing committee and its medical council shall meet periodically to observe rules and procedures in regard to the efficient functioning of the corporation. Such observations can be specified as per the regulations in regard to the meeting also. Now, supersessions of the corporation standing committee. The supersession of the corporation and standing committee occurs when there is a persistent failure to perform the duties prescribed to both parties. In such a case, the central government, via notifications of the office gazette, can take the place of the corporations, or with the consultations of the corporations can take the place of the standing committee. Now, duties of the Medical Benefits Council. The Medical Council functions as follows: advise to other two ESI's bodies and matters relating to the implementations that would be beneficial in the medical fields. It acquired certifications for the grant of medical benefits. Now, duties of Director Generals. So, duties of the Deputy Generals is financial commissioners are prescribed by the ESI Act itself in accordance with the central government also. These tasks may concern various areas for management to miscellaneous tasks. Validity of the Act of the Corporations. Not act of any ESI body shall be termed as invalid with respect to their own rules and regulations. Invalidity can be claimed on the eligibility and ineligibility of a particular members of the office. Regional board and local committees. Regional board and local committees. Corporation may appoint regional boards, local committees, and regional local medical benefit councils in such areas and in such manner, and delegate to them powers and functions. Now, the expenses of funds. The ESI funds is responsible for maintaining the expense of ESI, which are as follows: payment of benefits and provisions of medical treatment and attendance to insured persons and their families if required, payment of fees and allowances to members of the corporation, the standing committee and the medical benefit council, the regional board, local committee, and regional and local medical benefit council also. Payment of state leave and joining time allowances, traveling and compensatory allowances, gratitudes and compensate allowances, pensions, etc. So, establishment and maintenance of hospitals, dispensaries and other constitutions, and the provisions of the medicals and other ancillary services for the benefit of insured persons and their families if required. So, payment of contributions to any state government, local authority, or any private body or individuals towards the cost of medical treatment and attendance provided to insurance or insured persons and their families if required. Administered expenses. The administered expenses are termed so these expenses which cover the cost of administrations of ESI prescribed by the central government also. Holding of property. ESI is subject to conditions prescribed by the central government, and it terms to acquiring, hold, sale, to transfer any property movable or immovable, vested in or acquired by it so as to fulfill the purposes of the corporations. The ESI also has the ability to invest in property as when required under the jurisdictions of the central government. So it can also delegate property for the benefit of its staff. Vesting of the property in the corporations also, and budget estimates. Every year ESI frames and projects a potential budget showcasing how much expenditure it processes in incur and how it will discharge its liabilities during the following years. So this is then submitted to the central government for approval also. Audit. The central corporation prepares accounts regularly, which are audited annually by the Comptroller and the Audit General of the India, and any audit which leads to an expenditure will be payable to the above parties. So any person appointed by the Comptroller and the Audit General to act on their behalf will temporarily have the same power as the above parties and are authorized to demand the production of books, accounts, and connected vouchers and other documents and papers. They shall also be authorized to inspect any offices of ESI at any time. The account of the corporate before being forwarded to central government have to be verified by the comptroller and audit general or any of their respected representative also. So after verifications, the accounts can be forwarded to the general government along with any comments of the report given by the above parties. Now budget etc. to be placed before parliament and valuation of asset and liabilities, the corporation shall at intervals of 3 years also have an valuations of its assets and liabilities made by a valuer appointed with the approval of the central government, provided that it shall be open to the central government is to direct and valuations to the made at such other times as it may consider necessary. Now contributions, the contribution is determinables amount of money payable by both of the employer and the employees as per situations to the corporations. The rates, while usually prescribed by the government, are not set in stone and are subject to change. Rates defined by the government are mostly as the unit standard for the contributions payable by the employer. In case of the employees' contributions, the wage period in relations to the respective employee shall be held as a unit to determine the compensation payable and are normally due to on the last day of the wage period. So failure to pay contributions by the employer will make him liable to pay an interest rate of 12%. Now principal employer to pay contribution the first instance. The primary employer has to collectively pay the contributions, both his own and that of his employees also, regardless of whether they are directly employed under him or are working through an immediate employer. So if a directly employed employee fail to pay his contribution, then the employer can recover that contributions only by deducting the wages of said employees. Now recovery of contributions from the immediate employer. In case of the employee who is indirectly employed under the principal employer via an immediate employee, so the principal employer shall be entitled to recover the payment made on behalf of an indirect employee from the immediate employer as a debt payable to him. So the immediate employer also has to prepare a list of all the employees under him and submit the same to the principal employer before paying his duties. Now general provisions as the payment of contributions. In case an employee's wage falls below the prescribed wages range prescribed by the central government, the employees shall not be liable for his contributions and it shall not payable. So method of the payment of contributions, the manner for employment of the Act provides regulations for has been elaborated in the following conditions: the nature and time of the contributions being paid, payment which involves the uses of stamps or other fixed upon the books of accounts or any other documents, the evidence of the contributions which reaches the corporations is to be dated, the different entries in books of accounts along with details of the insured persons, and of the replacement of the documents which have been lost, destroyed or defaced. Now employer to furnish returns and maintain register in certain cases. According to the provisions given as per the ESI Act, the principal and immediate employers are to submit all the investment profits as well as any and all details relating to their employees in any factories under their jurisdictions. In case of the failure to submit a return that the corporation had responsible cause to believe should have been submitted, the corporations can require the employees to represent all the details also, and the social security officers and their functions. ESI has the power to appoint persons and social security officers. Their functions are mostly to serve a role in inspecting their functions of the corporations. If required, he acquired any informations from any employer as he sees it. He can enter any corporations at any time and can get all the accounts, books and other employment documents also represents to him without any due notices. So these can include informations like wages, expenses, etc. He can inspect and look into any matter regarding the employers and employees as when he required under the jurisdictions of the court, and he can make copies of take extracts of his register of account back as per his discretions. Now, determination of contribution in certain cases. So, a social security offer is restricted from exercising his functions and discharging his duties also. So, if the account statements of the factory establishment are not submitted or not maintained in accordance with Section 44 of the ESI Act, as such, the corporations may, with the available informations, determines the contributions defined under Section 39, amount payable to employees. However, these procedures will not take place until after the person in charge has been given a reasonable opportunity to be heard regarding the absence of such records. So that's for the video, my friends. If you like my videos, please subscribe, like, comments on my video. Thanks a lot for watching.